and welcome to Facing Change, our series of fireside chats with leading industry experts on the impact the current crisis is having on anti-money laundering and anti-fraud efforts across UK business. Today is a special extended edition, as we're very lucky to be joined by two of the UK's legal sector anti-money laundering regulatory bodies, Graham Mackenzie of the Law Society of Scotland and Colette Best of the Solicitors Regulation Authority for England and Wales. Welcome to you both. Perhaps I could start by asking each of you to give a brief description of your roles, how you set up and how that might have changed during this crisis. So perhaps, Colette, I could start with you.
Yeah, of course. Thanks very much for inviting me on. I am literally sat by my fireside from home, so nice to do an actual fireside chat. So I'm Director of Anti-Money Laundering at the Solicitors Regulation Authority. I also chair the Anti-Money Laundering Supervisors Forum. At the SRA, we have a dedicated money laundering team, so we comprise just over a dozen people, which is split up into three teams. A policy team, which deals with a lot of the legislation and training. We have an investigation team of AML specialists that deal with complaints. And then we have a proactive AML supervision team who go out and do visits, thematic reviews, and desk-based reviews. I think it's fair to say that things have changed quite a lot for us over the last few months. We, as an organisation, don't all work from home on a regular basis. My team tend to work from home perhaps one day a week. So we've had to move to a situation where the entire organisation is working from home. Which has been, I think, challenging. But I think, one of the solaces I take from this that it's happening in 2020. If it had happened 10, 20 years or so ago, things would have been so much worse. So we are now all set up from working from home. And actually, it's going really well. We've seen a real spike in productivity. People are reasonably content working from home. And we can do more or less everything that we would do ordinarily. Obviously, visits are happening over the phone rather than face-to-face. And we miss seeing our colleagues. But for the most part, I think it's going pretty well.
So, Graham, how's the situation for you in Scotland?
Hi, Mike. Firstly, many thanks for inviting me to chat today. A pleasure to do so. By way of introduction, I head up the AML team at the Law Society of Scotland. We are a small team which is supervisory in nature, and we help Scottish legal firms recognise the AML and financial crime risks they face by undertaking risk-based assurance across the supervised population to ensure, as far as possible, compliance with the money laundering regulations. So we're having to adapt in terms of our supervision to far more desktop-based work using technology to contact and request information from firms. It has, of course, also provided an opportunity to reassess our ways of working, which in turn I expect to have positive outcomes for us.
Thank you both. That really echoes what we've been hearing from other sectors during this series and really shows how adaptive and creative we've become through this crisis in making things happen. And as you say, that technology has played a big part in that. So let's turn our attention to the pre-COVID world, if we may. As regulators, you've had the challenging role of supervising law firms and making sure that their AML and CFT controls are effective and remain effective throughout this crisis. And it's true that law firms play an obviously important role in preventing financial crime. There's also been a lot of media attention in this area over the last 12 months, so perhaps I can ask each of you to give an update on progress that's been made in your jurisdictions.
Yeah, sure. So at the SRA, I guess early last year, we took the decision to create a dedicated money laundering team, which involved some reallocating of staff within the SRA, but some recruitment. So the last year for us has really been about setting up the dedicated team, doing some recruitment, and we've got an absolutely fantastic team now of some existing SRA staff. Some people have come from industry. industry, and quite a diverse team who I'm really proud to work with. They're a really fantastic team. So a lot of that work has been setting out our approach to supervising money laundering, and we have a 3-pillar approach, as I think a lot of people know. So part of that is preventative, so providing advice and guidance to help firms comply with the regulations and prevent money laundering. Part of it is proactive supervision, which is something that we haven't really done as an organisation to this extent in the past. So that involves the firm visits, which I mentioned a moment ago, desk-based reviews to look at firms' policies, procedures and controls and risk assessments, and thematic reviews. And then the third part is reactive supervision. So that is obviously responding to complaints, but all of the money laundering issues are now dealt with by a team of specialists. And we work very hard to share information with law enforcement, the National Crime Agency, other supervisors. And I think we've made a lot of progress over the last year. In terms of the biggest challenge, I think for me, probably culture in firms is the biggest challenge for us. A lot of problems we see sort of flow from firms taking a sort of a tick box approach to compliance or not taking the responsibilities seriously. So I guess our message is that responsibility it goes throughout the firm. You can't delegate money laundering responsibility to one or two people in your compliance function. It really is something that it's important that everyone in the firm understands the importance of, knows where the risks lie, and take action where you see something suspicious or something that doesn't feel quite right. And that's to prevent money laundering, but also to protect your firm. And I think the role of the money laundering reporting officer, the newer role of money laundering compliance officer are really important in embedding that sort of cultural approach throughout the firm. The money laundering compliance officer is a really important role. It's the person that's supposed to ensure that the firm as a whole complies with the money laundering regulations and has appropriate processes in place. So making sure that the right person is in that role, that they have appropriate training, that they have the right power within the firm to sort of embed that culture of compliance is really important.
And Graham, what's been the situation in Scotland?
Yeah, so it's been a very busy year for us. We've established a new AML committee with experts from a variety of backgrounds across law enforcement, financial services and the legal sector to inform the decisions we take as a professional body supervisor. I think this can only be a positive move. We have strengthened our internal AML governance structure. For example, we have strengthened our AML policy, internal AML policy, and I think that will reap great benefits for us. We've revised our risk-based approach to AML supervision. We have conducted our first ever thematic on trust and company service provision within the Scottish legal sector, and that's gone down really well. We have revamped the AML content on our website. And we've worked with colleagues across the UK to refresh the UK legal sector AML guidance, and that's due to be published later this summer. So yeah, and indeed, in terms of challenges, we're working hard to embed our new processes and new supervisory approach across our supervised population, and of course internally as well. And I think one of the challenges that we face in the Scottish legal sector is the diversity of the market that we supervise, with such a broad range of risks and risk profiles. And that's a challenge. We have the largest proportion of our supervised population is small high street practitioners dotted across Scotland, but also we do have larger multinational firms. What does this mean for us? Well, yes, we do have some of the higher end money laundering risks in the legal sector that we've seen making the news, but we can't also lose sight of the lower end localised proceeds of crime, which blights local communities here in Scotland and across the UK. And how we capture and account for these spectrum of risks is a challenge that we continue to grapple with.
So just from a law firm perspective, what are you sensing? Are you seeing a much greater awareness amongst firms about the need for AML controls to be done correctly? Have you seen a sea change in the response from firms to this crisis?
Certainly, firms that have previously embraced technology and integrated it successfully in terms of remote working, of course, but also document and financial management may well have a head start in this crisis, no doubt. Processes which have client services and needs at the heart will ultimately help maintain standards and, of course, will be of an advantage coming out of the lockdown. These, of course, must be balanced with strong internal controls, however. Of course, as a supervisor, that is very important to me.
How about you, Colette? What sort of trends are you seeing? Anything different?
Yeah, of course. I think the very vast majority of solicitors and firms that we deal with take this seriously and really genuinely want to do the right thing. I think the challenge that we have is that there's still a small but significant minority that don't take this seriously. That's what keeps our investigation team in cases. And I think there's potential here for a small minority to do significant damage to the reputation of the sector as a whole. So it's a reputational issue. And also those firms are acting as gatekeepers to assets and in a position of trust. So it is disappointing that we do still see a small minority of firms that don't take their responsibility seriously. But as I said, I think that is a minority, and the vast majority of firms that we deal with are doing this really well and trying very hard to get this right.
That's really encouraging to hear. Sorry, Graham, you had something to add.
So, well, the legal landscape is extremely diverse. As I've said, up here in Scotland particularly, we have firms of all different shapes and sizes with dramatically different business models and resources in terms of people, technology, financial reserves, etc. So clearly firms are adapting in different ways and at different paces.
That's a really interesting point. You don't really think about that aspect. There's a wide spectrum of firms that all have to comply to regulations, but with very different levels of experience and resources available. It's no doubt challenging. Now, just recently, an advisory note was issued by both regulatory bodies to law firms, updating guidance to them on regulatory compliance matters, particularly recognising the challenges in carrying out CDD, customer due diligence checks, and the practical difficulties of identity verification and reporting. Could you perhaps summarise what your approach as a regulator will be during this crisis, and perhaps highlight one or two of the areas you've called out? I'm thinking particularly onboarding. Colette, perhaps starting with you.
Yeah, sure. So we're monitoring the situation very closely. It still feels like we're in relatively early days here, but we understand that it is a massive challenge for the sector at the moment. And actually the impact probably won't be apparent for quite some time. So you've got the initial impact of lockdown, and then a sustained impact probably of a downturn and quite a hard economic situation. So our position is that actually the standards remain exactly the same that are required by us at the SRA, and also in the money laundering regulations. That absolutely hasn't changed. What might change is how you go about meeting those standards. So we've published, as you mentioned, the LSEG Legal Sector Affinity Group guidance, which is across the entirety of the legal sector. There's also some Q&A on the SRA website, and I'd also particularly draw firms' attention to some notes that we've put out on cybercrime, because we think that's going to be a major issue. In terms of the guidance note, yes, I think onboarding is going to be a challenge for firms. As I say, the standard remains exactly the same, and that if firms aren't confident that they're able to properly identify a client, that they shouldn't act. Again, I think probably during lockdown, the number of new clients has probably been reasonably small, so I think this challenge will continue to grow for firms. But we are still very heavily monitoring the situation.
Yes, an evolving situation, I can imagine. Graham, how about from a Scottish perspective? Anything different?
So, well, in terms of the impact on Scottish firms, well, the legal sector in Scotland has been dramatically impacted, no doubt about it. We've got 90% of firms who have faced a reduced turnover. Almost a quarter of Scottish solicitors in private practice have been furloughed. The legal profession, I would suggest, has responded, however, with agility, but current conditions are very challenging, no doubt about it. There's been areas of legal practice really hit hard. Property transactions, for example, remains an obvious problematic area. I guess the main challenges from a regulatory perspective is acknowledging and balancing the extreme pressures which legal firms are under, with my duty, of course, to provide effective supervision. Social distancing means my team cannot conduct on-site visits, so this means more desktop review. We are being as flexible as possible, where firms are retrieving data stored in hard copy, for example, from their offices. Is our approach any different here in Scotland? Well, the regulations, of course, are pan-UK, although the size and the nature and the risk profile of our respective supervised populations is, to a certain extent, different. We have to consider this along with the relative resources that we have. That said, I wouldn't see a huge divergence, no.
Interesting. Thanks, Graham. A lot of challenges I'm hearing in the present situation. It's clear that financial crime isn't diminishing. In fact, we've seen in the media a sharp increase in fraud and financial crime related to COVID-19. Clearly, we can't let our guard down, but something you touched on earlier is so important, and I'd ask you to touch on it a bit more now. That's about encouraging firms to take more of a risk-based approach. We know it's key, it's embedded in regulation. How do you do that now in the current climate that makes sure that our defences aren't breached too easily? Colette, can you start again for us, please?
So yeah, I think the risk-based approach is really important, and I think we are likely to see a sharp increase in attempts to defraud and to undertake financial crime by criminals. I think law firms are very experienced in dealing with these risks. You know, we've seen things like this in the past. So, for example, after the New Zealand earthquake, there were fraudulent websites set up literally within minutes. And the legal sector is used to dealing with those sorts of threats. What I would say is that criminals adapt to the market very swiftly, and we're seeing a very quick shift in the economic market. And that's probably going to lead to innovation by criminals, which in turn leads to lots of new risks, lots of people out of work potentially, which could be targets for criminals. So firms need to be alive to those new risks, and the whole risk-based approach is predicated on being aware of your risks. So we'd advise firms to be keeping an eye on the NCA websites, our websites, government websites. The Financial Action Task Force has just put out some useful information. And I guess I'd just stress a kind of a thoughtful and considered approach, making sure that firms document their decisions, where they're taking decisions, and need to think about how you change your policies, procedures and controls for the current environment if necessary. And I think, to borrow a phrase of our Prime Minister, stay alert.
Stay alert. Yes, I like it. Thanks, Colette. Graham, how about you? Your reflections on the risk-based approach?
Well, certainly, I think obtaining requisite information to undertake a proper risk assessment can be really challenging in the current environment. Risks themselves are, of course, changing. Legal firms need to be aware of that. And what was once low risk may well be high risk now, and vice versa. Solicitors, I guess, need to ask really hard questions. Businesses whose cash flows should be stopped due to a lockdown, why are they still buying property, able to buy property, or why are they still investing? Of course, as a supervisor, I may be concerned if I see a movement of resource away from compliance into other more income generating areas to keep the wheels turning or generate, I guess, much needed cash flow from a business perspective. this could obviously be a particularly dangerous move.
Absolutely. And we've heard that consistently from other practitioners. Concerns that compliance resources are being diverted and the associated risks of that being able to keep up AML standards and taking a risk-based approach. Anecdotally, has the legal sector seen a noticeable spike in cases of fraud and money laundering since the crisis began? I'm wondering if you're anticipating a spike in financial crime in the coming months. Graham?
Yeah, Mike, I think there are some very real money laundering risks associated with the crisis, no doubt. In situations like this, there will be some who seek to exploit perceived vulnerabilities. And as some cash-based routes close, it may be that the legal profession comes under increasing threat. So unfortunately, I'd say yes to your question. I probably do anticipate a spike, unfortunately. As a responsible supervisor, it is, of course, our duty to bring those threats to the attention of legal firms.
So, Colette, yes, your response to the potential spike.
I think we're expecting it. All the indications from the National Crime Agency and others are flagging that they're beginning to see spikes in reports. So I think, as I say, attempts are coming. Whether or not they're successful really depends on the sort of the awareness and the policies, procedures and controls that firms have in place. So fraud and financial crime, I think, are big risks. Also, cybercrime is a big risk at the moment. Information security has really never been so important. We have on our website, on our priority risks page, some updates on cybercrime and information security. So would advise firms to take a look at those. And also, as I mentioned, we've got some frequently asked questions which we're updating as things move on the coronavirus situation in general. So if firms have questions, if there's stuff that you think we should be covering, then please do get in touch, because we do revise those on a regular basis, and we'll seek to put out as much and as helpful information as we possibly can. But I think we are in this for the long haul. This isn't, a 6-week spike in financial crime. I think the bigger challenge is the economic situation and the opportunities that creates for financial crime. So I think firms will have to remain incredibly vigilant for the foreseeable future. I think one of the challenges that firms have is identifying unusual transactions or unusual clients or unusual situations, when sort of everything is really unusual at the moment. We're in a really different world to what we were 3 months or so ago. So firms need to take care to try and identify if someone is acting unusually. Is that because of the current lockdown or economic situation, or is that because they're seeking to launder money or commit fraud? And that is something that I think will continue to be quite challenging for firms.
Absolutely. And I'm guessing on the back of this, we'll see a rise in SARS as time goes on. And the National Financial Intelligence Unit in the NCA will be very busy, I suspect. That'll be from all sectors, but it will be an outcome of this situation. Just talking a little bit about reporting, and you've covered this a bit in your comments so far, but your respective advice to law firms about reporting will have changed. Your ability to do on-site audit will have changed. Any messages you'd like to get across to law firms that reflect these changes? And would you like to quickly summarise your approach at the present time?
So our approach has changed and it hasn't. So the standards that we're upholding and the outcomes that we're trying to achieve remains exactly the same. The visits that we would have done face-to-face, we're now doing over the phone, and our desk-based work is going ahead as planned. That said, we are giving firms longer to respond, and if firms come back to us to say that they're really struggling because of staff sickness or access to files, then we're obviously sympathetic to requests for extensions. But the firms that we've dealt with have been incredibly helpful and incredibly on board with this, so really appreciate their cooperation. In terms of reporting requirements, yes, I think we probably will expect to see an uptick in suspicious activity reports. The obligations of submitting suspicious activity reports are exactly the same. Nothing has changed here. And in terms of regulatory obligations, firms that we supervise are required to report material breaches to us, including breaches of our regulations or regulations of another approved regulator. So if a firm is dual supervised by ourselves and by Law Society Scotland and breach one of Law Society Scotland's rules, they need to report that to us, and we expect that to continue. And I guess the message for firms is keep an eye on what ISARs you're seeing, what internal suspicious activity reports you're seeing. Is the number going up? Is it tailing? That's a really good sort of health indicator of how good you are at identifying suspicious activity throughout the firm.
Very good points. Graham, your thoughts around this?
So in terms of SAR reporting, we have recently issued an email to all MLROs within the Scottish legal sector advising of the requirement to continue to submit SARs. Firms and MLROs need to be aware of this and of the increasing and changing landscape when considering internal reports and whether to report externally, of course. What was once questionable or indeed suspicious may just not be in the current environment, and vice versa. Activity which may have been normal and run-of-the-mill 2 or 3 months ago may suddenly be suspect. So effective reporting, I guess, has just never been harder. And we continue to work closely with the UK FIU, along with others, to highlight these sectoral issues to our supervised population.
Well, final thoughts. I think you've both touched on some really important themes here, and the important word seems to be change. We won't be going back to a pre-COVID norm. There'll be a new norm, and that will look very different. The risk landscape is changing rapidly, and firms will have to deal with that. So as we draw to a close, can I ask you both your final thoughts on how we can learn, what benefits there might be? There's a lot of discussion towards the acceleration of digitization, for example. So your general thoughts on how we go forward from here. Colette, may I ask you first?
Yeah, I absolutely agree that this is probably going to be a long-term change, and we're going to be seeing a lot of change for the next few years. I think firms' processes, there's no one size fits all. It's a good time to look at your policies, procedures and controls. But that's not to say you need to tear them up and start from scratch. You don't need to get consultants in to do a complete overhaul. It's about adapting to the market, and I think about keeping in mind new risks. You asked for my personal thoughts and reflections. I think money laundering can often be seen as a victimless crime, whereas actually the cost of money laundering to the UK is around £37 billion per year. And actually that money would be really helpful at the moment to fund the NHS for researching a vaccine and supporting those who are out of work. So I think it's time for the sector to come together, all of us to come together to work towards preventing money laundering. And then in terms of the transformation to digital, I think I said earlier that one of my solace in all of this is that, it would have been so much worse 20 so years or so ago. And actually, I think this will accelerate the move to digital. We've just published our new SRA corporate strategy for the 3 years ahead. And one of the key focuses of that is looking at technology and innovation. So we'll be looking at ways that we can remove barriers for firms who want to use technology, and looking at ways that we ourselves can use reg tech or technology in the way that we supervise. I think we will begin to see a kind of an increase in, for example, firms using electronic customer due diligence. And the Financial Action Task Force have put out some really useful guidance on this. So if you are selecting an electronic due diligence package, it's well worth taking a look at that. But ultimately, technology doesn't replace good human judgment and personal responsibility. You can't delegate decisions to technology. So human judgment and the personal touch still remains really important.
Absolutely. Thank you, Colette. And your final thoughts, Graham?
Okay, so final thoughts. Well, firstly, I think firms will have to remain cautious, especially where levels of business have dropped or they may be suffering financially. I guess it's all too easy in this situation to succumb to the temptation of a criminal angel investor, for example, who offers fast cash to prop up an ailing business. The legitimate services and reputation of the legal sector offers, I guess, an attractive proposition to criminals with cash to invest. And bearing in mind that criminals are often the first back into markets, they don't need to go to a bank for capital. They've got the capital at hand. So you see it time and time again through the years where new or emerging markets, quite often the first capital into such markets is criminal in nature. And I think that's a very real risk across all sorts of business types and sectors. And firms will really need to think hard about that when conducting CDD. Also, when conducting CDD also on their clients as well as internally within their own business models. Another couple of points, if I may, Mike. Well, firms will require to adapt and realign risk assessment methodology, certainly on an interim basis and potentially on a longer term basis too. They need to communicate these risks and any control changes across their businesses and train staff accordingly. And importantly, senior management should also be aware of changes to their firm's risk profile and, of course, the risk profile of the businesses that they are responsible for. Well, and also, I think, finally, there's no question that the longer term legacy of the pandemic will primarily be of digital transformation. I think remote working and all that this brings will result in a much more dynamic and flexible and possibly, hopefully, agile profession as well. It may also encourage diversification in the services that firms provide. I think it's particularly difficult at the moment, and must be, if you specialise in, for example, high volume conveyancing with tight margins. Fundamentally, a clearly trained focus on the client will be a great aid, I guess, in weathering that particular storm, as it is in any market, coupled with strong internal controls around AML and financial crime.